What's up, y'all? Welcome back to my YouTube channel. My name is Gary Branch. I'm the owner of New Gen Wealth Solutions, and I'm here today. I just want to speak about stop letting the debt collection agencies play on your top. Stop letting them play with you. Debt collectors really don't have no ground. Laws were put in place, the Fair Debt Collection Practices Act, the FDCPA. Google it, look it up, read it. Lawsuits from debt collectors, there's so many different ways to beat them. I'm just going to go over some of the things that I just did. As you can see, this one was filed 6-4. Portfolio Recovery Associates hereby voluntarily dismisses this action without prejudice. And then I have another one that you see was filed 6-17. LVNB Funding, they dismissed without prejudice. This was two of my recent dismissals of lawsuits. Now, I got a video. Go back and look at it that I posted when I was saying how the lawyer from it was LVNB Funding, if I remember correctly, how they were speaking in court, and they was like they couldn't believe how that letter was worded. And I knew when my client told me, I knew it was a win. First of all, this is for entertainment purposes only. I'm not a lawyer. I do not give legal advice. I can help with document preparation in certain instances and things like that for my clients. Both of these were recently done. Didn't use a lawyer, none of that, because the laws are in place to protect you. Get out of that mind frame that, it's stacked up against me and it's meant for the company. No, there was a time where collection companies and the credit reporting agencies and all of the data furnishers, the banks, all that stuff was able to do anything they wanted to do with everybody. Congress stepped in, saw that it wasn't unfair, and they wrote the FCRA, the FDCPA, TILA, and other laws. And these are laws that protect you, the consumer, and you just have to know how to work them. So now, first of all, when you get one of those summons, do not run from it. First of all, if they don't serve you, in most states it's not valid. So if something coming in the mail, it might not be valid. You have to check your specific state laws. But in most cases, you got to get a lawsuit, right? You got to get served, I meant to say. So when you get served, a couple of things that I like to ask my client is this debt valid? Is it really yours? How long do you have to respond? You want to respond on time, but there's time you can respond late. Now, if you were served, did they serve it to the right address? Did they serve it to a minor? Did they serve it to a family member and not to yourself? And then you got to look at that paper, that summons, that claim, and you have to accept, agree, or deny all allegations. I'm not telling you what to do. I'm not telling you what, I'm gonna cover this up right here because I'm not telling you what to do. I'm not telling you to accept, deny. I'm not telling you none of that. But you have to accept, agree, or deny the allegations. But by law, you have to respond to every single line of that summons. And that's how you get them, right? But ChatGPT is a very wonderful thing in 2024. ChatGPT is a very wonderful thing. Now, me, I know the laws. I use my knowledge mixed with ChatGPT. So it's not something as simple as just dropping it all in ChatGPT and letting it be. What you can do is you drop it in there, copy and paste that, drop it in ChatGPT and tell them to respond and accept, agree, or deny all allegations. Then whatever ChatGPT spit back out to you, that's when you can take and you can mix it up, chop some stuff out, add some stuff in, because every situation is going to be different. You might have had, I don't know what your situation was with this particular collection, but there could have been some situation like maybe you bought a lemon of a car, but there are several different things that can go down. Now, another thing is this. You can search agreement database. You see I'm giving you one right here, but you can just Google whatever the company is, the original creditor, and see if you had an arbitration clause in there. Because that's another thing. Arbitration clause, then you can tell them that they breach a contract. They didn't even give you a chance to do it in arbitration. They just sold your debt to a third party, and boom, now you're being sued by that third party. So you can also write a motion to compel arbitration back to the original creditor if you choose to do so. It's not always necessary. A lot of times you can just kill it at surface level with the collection company. But I'm telling you that once you kill that surface level with that collection company, that arbitration, it's open to get some money in arbitration against that original creditor because they did something wrong. So you definitely want to write your letter to dismiss the motion, right? You want to do that. You got to file that proper motion to dismiss. You want to tell them you want a failure to state a claim. If you're going to do arbitration, add a third party debt collector for breach of privacy. when they actually wanted to add anything else. So you can sue the original creditor and that debt collector. But let's get back on. I can get all over the place. I got a little ADD. I can get all over the place. Now, ADHD, I got it. I can get all over the place. But let's get back to what I was talking about dropping this lawsuit. Now, these are the things that you can put in your motion to dismiss. If you were improper address, a minor got served, they served a family member. It may be under the FDCPA, you got to look it up, Fair Debt Collection Practices Act. They talk about a lot of things that collection companies can't do, and you can mention that in there. In Florida, they can't even send an email like after 8, 9 o'clock at night or before 8 in the morning. Maybe they were harassing you. Maybe they threatened you. Maybe they sent some deceptive forms and things like that. There are so many things in the FDCPA. I'm going to type it up. Let me give you some context. I like to show stuff. FDCPA, here it goes, the Fair Debt Collection Practices Act. You have to read over it. You have to familiarize yourself with it. I know you're not a lawyer, but unless you want to be paying people like me to do this for you, you got to learn to do it yourself. That's it. Got to learn to do it yourself, right? Now, that's 2 lawsuits that was deleted. Now, here are some things that I put in my letters in addition to whatever my client's specific situation is. I'm letting them know that this is a response to an insufficient validatement statement letter they sent me. It's not accurate. It can't be validated. I got the right to request and receive validation of alleged debt. I asked if they provide me what? What is this account balance for? I need a complete audit trail calculation, including a complete payment history of the account. Where's the documentation? I agreed to pay the debt with the signature. Where did I give you permission to have my information? And where's the paperwork showing that I gave you authorization to report this to my credit? No consent to you having it and you using my social security number, you stealing my identity. And I'm gonna report you because I didn't give you permission. What are you doing with my social security number? Where's the agreement that grant them authority to collect the debt? You wanna see that agreement. That original agreement, a lot of times will have stuff in it that basically says it's inaccurate. So now you wanna get a copy of the state license, the license number, that get them the right to collect in your state. You want the purchase agreement showing where they purchase your personal information without your consent, which is fraud because you're unknown to me. I never did business with you. Again, this is important right here. That purchase agreement. And I always ask them, if this is really mine, have a senior executive officer swear under oath that it was me, right? I want the original promissory note on the debt. And, then I put some other stuff out the FDCPA, like furnishing deceptive forms and stuff like that. Now, all of this is cool for the letter to the debt collection company. But let me go back to a summons, right? I don't have the summons right here. I don't have the claim. Let's see if I can just get a summons or a claim off of, let's just see if I can get one. Summons for debt collection. Let's just see if I can just find one somewhere on here, right? I doubt if I can just find one. But that summons, you have to respond to the summons line by line. And you could basically just go right into ChatGPT and do it, right? I don't have a summons right here to do it. I can't show you my client's information and just give you a whole how to beat a lawsuit right here on YouTube. I can't do all that. I do have a group that I'm coming out with. It's called the Wealth Legacy Club. It's going to be on School. I'm going to teach this stuff right in there. It's going to be a very low price because I'm going to help change some people's life this year. I've been doing for the past 4 years, but I'm going a little bit harder this year. Now, if you want more content like this, I want you to like, follow, subscribe, check me out. I will have some links in the description if you want to book a call with one of my team members. I will have a link in the description for my new school program that's going to teach you stuff like this. I'm going to go more in depth, have weekly Zoom meetings and stuff like that. But again, don't run from these people. They're nobodies. Don't run from them. Answer those summons. You get that summons, you get that claim, you answer line by line. You look at that original agreement, you see if it's an arbitration clause in this, so you know that you have that's another way out. If it don't work this way, you compel arbitration. And you send them a debt validation letter. And when you send it, you want to send a copy to the courts. That's your motion. It all goes in a motion. You want to put that on file at the courts, and you want to send everything to their lawyer as well. The letter, your dismissal, all that stuff there that you're asking for to be your motion to dismiss. You want to send all that stuff off to the lawyers, and then you wait for your response. You just wait. I know that this client right here, this particular client knows this one. I know that she was ready to go, and it was like the next day she had court. She got this that Friday when she had court Monday. And I love this one because when she went in court with hers. She was a little late with it. That's what I'm telling you. But she showed up in court with the entire response to the summons and claim, the entire response to that, and a letter. And the lawyer was wild by it. They were wild by it. Why? Because I studied the FDCPA and I guide my clients. I'm not a lawyer. This is not legal advice. I do document preparation. Hey, if you want to see more stuff like this, I want you to follow. I want you to share. Let's get it.